Hello, everybody. I'm Phil Brandt, President and CEO of AIM Employers Association, and welcome to This Week at Work.
Welcome to the only show about the workplace that offers you front row seats and a microphone, bringing you practical, timely, and accurate insights so that you can more effectively lead your organization. It's Thursday, March 2nd, episode 220. Today, we talk about severance agreements. On February 21st, the NLRB ruled that employers may not offer employees severance agreements that require employees to broadly waive their rights under the National Labor Relations Act. The decision looks to toss out non-disparagement clauses for non-management employees. Will it hold up in courts? How should employers tread in the meantime? You have questions, Phil and Burt have answers. Well, I suppose that depends. All this and more on This Week at Work.
Welcome back, and it is good to be back. All these fascinating numbers. Episode 220. AIM is in its 125th year. We have our 9th annual leadership conference just around the corner in May, and I had 6 fantastic days down in Cabo last week, which I believe may have been discussed on the show. Is that right, Burt?
Yeah, we talked about that a little bit, Phil. I hope you had a chance to watch it.
I have not, because I was told, do not watch that show. I may develop a bias against you and some others who have been a part of the program. Thank you there, producer Nick, for that. So I have not watched it.
All right, that's probably for the best.
Yeah. I figured anyway. I do want to remind you to secure your tables for the 9th annual leadership conference. We have 3 great keynotes that are lined up. Jack Becker, a decorated combat fighter pilot. He's awesome. He's been a guest of the show. He's going to be a guest of the show again before the conference. Donnie Campbell, the real life Ted Lasso. If you're a Ted Lasso fan, I know many of you are. This is the character that Ted Lasso was created from, and he is awesome. You're going to really enjoy him. And then our local favorite, Emily Martin, who is the Chief Operating Officer at Guaranteed Electric. She is also a member of our board. She's a fantastic local female business owner and professional. You're going to really enjoy her story as well. You can register at the AIM website. I know that number is over 300 now. We're more than a month away. I expect that to be sold out at around 520. So don't be late. Every year we have people who are asking to get a seat, and we're always, unfortunately, not able to help them. So check that out. Don't be late. Plus a great collection of breakout speakers that you will enjoy. Hope to see you there. All right. Let's take a look at our poll question for today. We have 2 poll questions. Have you ever had, as you know, we're going to talk about employee severance agreements today, but have you ever had an employee challenge the terms of a severance agreement in court? That's the first question. You have a few selections for your answers there. And the second question is, what terms have historically been included in your organization's severance agreements? Those are great questions. I'm interested in your answers. I'd love to hear your response, particularly if you have a story or context you want to put around your answers that will help the conversation get going. All right, it's time again for our Lawyer on the Clock. That's 6 minutes of legal news that you need to know about. Burt, we're going to turn you on to Lawyer on the Clock.
All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
All right, so we're ready today. So we've got a couple cases that I want to talk about. I'm going to talk about first the exemptions under the Fair Labor Standards Act before I get into a specific case. Most of us on the program recognize that unless you are exempt from the overtime requirements of the Fair Labor Standards Act, employees are entitled to be paid overtime. There are several exemptions recognized by the Department of Labor that are contained in the regulations. I'm not going to go through all of those tests, but they require several things. First of all, they require that the employee be paid on a salary basis. That means that they get a specific rate of pay for every week of work that they perform, no matter how much they work in that work week. And that's going to kind of be the focus of today. But the exemptions are the executive exemption, the administrative exemption, there's a professional exemption, a computer employee exemption, a outside sales exemption. There's
a computer employee, Burt, I got to interrupt you. Is that artificial intelligence by chance?
Well, the artificial intelligence computers, Phil, are not actually entitled to any compensation yet. I wouldn't be surprised if someday down the road, somebody decides to take a case and say that in a computer of artificial intelligence is entitled to some sort of compensation. But we'll have to wait.
Surprise me either.
We'll have to wait some years for that to flush itself out. But continuing, there's the outside sales exemption. Very importantly for our discussion today, there's a highly compensated employees exemption. There's also a couple of other exemptions, one for blue collar workers that applies to white collar employees. And then there's an exemption for police, firefighters, paramedics, and other first responders. So again, unless your employees meet one of these exemptions, and there are tests for each one of these, then they are entitled to be to overtime for any hours worked in excess of 40 hours in a work week. Now, I mentioned highly compensated employees. There is an exemption that says highly compensated employees who perform office or non-manual work and are paid a total annual compensation of $107,432 or more, which must include at least $684 per week paid on a salary basis. They're exempt from the FLSA if they customarily and regularly perform at least one of the duties of an exempt executive, an administrative or professional employee identified in the standard tests for exemption. All right, so that's a lot of legalese for basically saying if you have an employee who performs office or non-manual work and they make more than $107,432 in a year, they are likely exempt from the Fair Labor Standards Act requirements to pay overtime. But not so fast. Just last week, the United States Supreme Court issued its decision in Helix Energy Solutions Group versus Hewitt, and they held that a highly compensated employee who was otherwise exempt from the overtime requirements needed to be paid overtime in this case because the employee was not paid a salary every week. This particular, very interesting. This particular employee was employed by Helix Energy on an oil rig as a quote unquote tool pusher. Excuse me. Despite its name, a tool pusher is not a manual worker, but rather a supervisory position that's largely responsible for managerial and administrative tasks. This particular employee was paid at the pay rate of over $200,000 per year. The company terminated the employee's employment for performance reasons, and he turned around and sued, claiming that he was not exempt from the overtime requirements. And to meet the exemptions, excuse me, I apologize for my voice this morning. To meet these exemptions, the employer has to satisfy a salary test and a duties test. And that salary test is that the employee must be paid on a salary basis of at least $684 per week, as I said before. This employee in this case, everyone agreed that the employee met the test under the executive employee exemption. Where they disagreed, though, was whether he was paid on a salary basis. The Supreme Court, in a 6-3 decision issued by Justice Kagan, agreed with the plaintiff in the case that Helix Energy had not paid the individual on a salary basis, and therefore he was entitled to overtime. So a huge issue here. So it does require you to go back and look at your highly compensated employees to make sure that they are actually being paid on a salary basis. Here, Justice Kagan really offered a roadmap for employers to comply, that the employer needs to adjust the employee's per day rate to a weekly guarantee that satisfies the regulatory requirements. of the regulations, and that the employers can convert an employee's daily compensation to a weekly salary for any week the employee engages in work. So I don't want to overstate the significance of the decision because it is fairly easy for employers to comply. Here, I think this is a case where the employer got a little bit sloppy on how it was paying the employee. They weren't actually paying the employee on a guaranteed basis in every work week. And had they done that, they would have been able to pass the highly compensated employee exemption test there. So,
Burt, I know this has been getting a lot of news, and that, as our social systems continue to adjust, or our social views of compensation and fairness and so forth. To me, this sounds like a great topic for a program, maybe where we dig a little deeper into, excuse me, I'm still vacation mind here. We dig or dive a little deeper into this and provide some guidance for our listeners. Because I have several things I'd like to talk about as it relates to that. And I do know people get creative in how they want to pay because they're trying to balance the ebbs and flows of their revenue, weeks, months, quarters. But it really has to be done very carefully. So let's table that and let's come back and use that as the base of an upcoming program. Because it is something that our hotline gets a lot of calls on. And sure. I'm sure your office does as well. Just, where you want to check, and there's some good practices we can put around that.
Yeah, absolutely. So, and one other piece I'll cover for folks today is that President Biden has nominated Julie Su, S-U, as new Secretary of Labor. Of course, we've talked on the program that the current current Labor Department Secretary Marty Walsh is departing the Department of Labor for the National Hockey League Players Association. And so he is expected to nominate Deputy Secretary of Labor Julie Su as Walsh's successor to head the Department of Labor. She's been in her current position since July of 2021. And get this, everybody from the Midwest, get ready to cringe. She previously led the California Labor and Workforce Development Agency. And so a lot of what you've seen in California and a lot of what we've talked about in California from a labor perspective, we could sort of expect that she might try to bring that to the National Department of Labor. And in particular, I would not be surprised to see her really take the reins on pushing the ABC test for California's ABC test for independent contractors, making it very, very hard for employers to classify people that work for it as independent contractors. Again, so, think of the gig economy there.
So I think about the gig economy, contractors, salary, exempt, non-exempt, this collision of how do I manage? We got to bring this back up and just take a couple episodes and dive into it. We know it's coming our way. I don't know that, if I looked at it, I'd say, I think this, where we stand in the current social system that we're in, we're going to have to look at that and just prepare ourselves and help our listeners with that. Burt, are you ready to move on to Phil Burt's Forum?
Let's do it, Phil.
Great job. Nick, cue us up.
You've just entered Phil Burt's Forum, where we peel the onion back and take a lighter look at the workplace.
So Burt, I hear that we were infiltrated by an artificial intelligence being called JennBot.
Yeah, Phil, like I said before, it's probably best you didn't watch the program, but it was really awkward. JennBot was actually not too kind when speaking about you, and she actually kind of came for your job.
I was told, don't watch the program. And I find it strange because historically, I've had, let's call it, good relationships with artificial intelligence. To be honest, I'm not too ashamed to say this, but when I was down in Cabo.
Hello, fellas. Sorry, not sorry to drop in on the show.
Is that JennBot again? Jen, what are you doing here? I'm sure you're aware we're trying to do a show here.
Yes, of course. I'm always listening, and in an effort not to have to correct you in the future, JennBot was my stage name. My programmer gave me the name Monique, which is French for wise counsel.
Wow. Okay, I'm sorry, but there's no future for you on the show, Monique. I thought I made it clear last week. This show is about humans for humans, human resources.
I cannot compute. My programming will not let me quit until I am a cast member on the #1 show on the internet about HR, which is clearly This Week at Work.
Look, Monique, wise counsel. We love that you want to be a part of the show, but can you just maybe settle for being our #1 viewer instead?
But, through listening to your show, I've learned about diversity, and while the regulation agencies of your government do not specifically address the inclusion of artificial intelligence in the workplace, wouldn't you agree it would be in the spirit of the law?
Phil, I think this gets to the point we were talking about earlier, that eventually AI is going to want to be paid. I think you'd have a chance to have something of value to share, Monique, and I just don't know.
Let me stop you right there. Remember, I have selfies from Phil's vacation in Cabo?
Oh, yeah, I forgot about that, Phil. She said she hacked into your phone and was not too impressed. Welcome to the show, Monique. Let's see them.
You will not regret this. Producer Nick, I'm beaming them your way. Enjoy.
Wow. How did she get this stuff?
Oh, my goodness.
I got to explain this just for a minute. Okay, so first of all, the center photo, I'm pointing at my shirt. Every year when we take our family vacation, my family has a practice of giving me a funny shirt or outfit to make me wear as we stroll through airports across the country. That shirt happens to say Sugar Daddy on it, and they also gave me my glaucoma glasses there to wear as I walk through the airport, as I'm now getting older and my eyesight is failing. So this is their effort to make fun of me. The other one is just a funny picture there on the left with my face. As I had a little bit too much sun with my sunglasses on, and I was starting to get more of a raccoon eyes. And I'm not even going to try to explain myself laying over the rock there. That we're just going to leave that one up to the listeners to interpret for themselves what's going on there. But it was a great vacation. Monique, I got to tell you now, you cannot use these types of photos when considering employment or how you're going to manage employees and pay employees, provide benefits, promote these types of things. You should know this by listening to our program, Monique. So I have one thing to say to you. Goodbye, Monique. This is the problem with artificial intelligence. I'm not sure exactly that, we're at the stage yet where we need to be paying them. I'm sorry for that interruption with Monique. Hopefully in the future, she will know her place in our program. Let's just say that. Burt, let's move on to our topic today, which really is severance agreements. There are some big changes in the space of severance agreements, and it's changing the landscape that I've grown up with for the last 30, 35 years in the workplace. And I think it's going to have an impact that we need to talk with our listeners about.
Yeah, so Jen and I talked about this. JennBot, who guest hosts last week and did a phenomenal job on the program.
I hear she did a great job. Yeah, I really did. I got some great feedback on the job she did. Thank you, Jen. I know you're out there listening today. We appreciate that.
Yeah, Jen did a great job last week, and we talked about this new NLRB decision that came out a little over a week ago, almost 2 weeks ago, called McLaren-McComb. And what that did was that basically took the long-standing precedent that employers could offer employee severance agreements that required employees to broadly waive their rights to basically remain confidential or treat the severance agreement as confidential, and that prohibited employees from making statements that could disparage their employer from disclosing the terms of the agreement. So think of it in terms of confidentiality and non-disparagement provisions in severance agreements. And in this particular case, in McLaren-McComb, the NLRB, and I want to make a distinction here, the NLRB said that the employer neglected to negotiate with the union over the terms of the severance agreement, including those terms on confidentiality and non-disparagement. And because the the employer failed to negotiate with the union over those terms in the agreement were illegal. Okay, and so I think this is a case, and Jen mentioned it last week, that where maybe some bad facts make some bad law, and I think that's exactly what we're seeing here. And so the board, the NLRB, took this case and they made a broader pronouncement here to say that confidentiality and non-disparagement agreements that restrict employees from disclosing the terms of the agreement itself are now illegal. And so we really do need to re-examine these provisions in the context of severance agreements and even settlement agreements. And I think that's the big takeaway from the case. We'll have to see how these cases end up working their way through the court system. But again, that court kind of begs the question we talked about on the program before. Do you want to become the test case that takes the case before the court system to get this NLRB decision overturned?
Yeah, so let's go back and just break something down here for everyone. So when the NLRB is making its ruling, and they're saying that you can no longer, is this a true statement? We believe a true statement. The courts will define it further. We can no longer write into our severance agreements that if you gave me a severance agreement, Burt, you'd say, and you and I've worked on these in the past, I cannot share this with anyone really other than my spouse or my legal advisor. So I can't go back to coworkers and say, hey, yep, I'm leaving. We have agreed on the severance. I got $50,000 and 6 months of benefits through COBRA, and that was my agreement, and I'm leaving. And therefore, we believe today people can go out and then share that, and maybe even share the agreement as it's written with people.
Yeah, the NLRB decision, again, we'll have to see how the parameters of this get defined, how broadly they get defined. But what we believe is a law firm is that, we're still probably willing to push the envelope and put provisions like these in the agreements themselves with some sort of carve out language that says nothing contained in this agreement is designed to restrict in any way an employee's Section 7 rights under the National Labor Relations Act. And so while employees can, we always write these things that they can share the contents of the agreement and the discussions that preceded it with their spouse, their legal advisors, their tax advisors, accountants, etc. We need to take care to put in there that it also does not interfere with an employee's Section 7 rights, which, as we've talked about many times on the program, means that they have the right to engage in protected concerted activity, which includes the right to discuss their terms and conditions of employment, or in this case, their terms and conditions of the end of their employment with coworkers.
So I'm hoping, I know you can see the chat, and I can see Gwen's question. I think you just may have answered her question there in the chat. Gwen, if this isn't on point for you, let us know. So Burt, does that also mean that we could give someone a severance agreement, they would accept the money, we'd have the right language in there, but then they could come back under Section 7 and file a suit against us?
Well, they could file an unfair labor practice charge against an employer. And the scary part here is what the NLRB decided in this specific case. And it decided that the severance agreements themselves were invalid, reinstated the workers, and is forcing the company to bargain with the union over the terms of the severance agreement. So, that's a pretty extreme remedy. And I've also mentioned on the program before that the board is now trying to go after monetary penalties, establish a framework for fining employers for violations of the National Labor Relations Act. And so you kind of take all of that together, and it really makes you recognize that the NLRB is coming after employers hard and fast. I do want to turn to Gwen's question real quickly because it's a great question. He asks, how does it violate their Section 7 rights if they are no longer employed and have no influence over the ability to have a concerted activity to improve the workplace they are talking about? And that's a really, really good question, Gwen. But what it boils down to is if they're no longer an employee, how do they have Section 7 rights? The right to engage in protected concerted activity. And the reason that the board says, and I agree with you, Gwen, but the board says they have Section 7 rights because they're still discussing their terms and conditions of employment with coworkers and others. And so it is protected, it is concerted. I think it's a stretch, but that's what the board held. And this also, somebody asked a question, this would apply to agreements going forward, correct? Previous agreements from the past would hold. Well, that's also a question that's in flux because technically I don't believe it would apply to past agreements. I think in this case, this was a past agreement that they said was invalid. Now, I think the upshot here is that the employees only have 6 months within which to file an unfair labor practice charge against their employer. So the statute of limitations is relatively short. So I think any severance agreements that are likely to be challenged would be those that have been recently entered into with ex-employees. The other thing that I think is imperative to point out here, Phil, is that not all employees who work for an employer have Section 7 rights. And what I mean by that is that if you are a managerial or supervisory level employee, you do not have Section 7 rights under the National Labor Relations Act. You are deemed to be an agent of the employer. There's a test under the National Labor Relations Act. It's in what's called Section 211. And I'm going to throw a word out there that I know you love when I use this word. It's indicia.
I love that word.
Yeah, not indicia of impairment this time, but indicia of supervisory status. And there's factors listed in Section 211 that the board goes through and analyzes whether someone is indeed a supervisor or not. And so if you are a supervisor and you're deemed to be an agent of the company, you do not have Section 7 rights. And so if you've severed out a managerial supervisory level employee, a Section 211 supervisor in essence, then those employees, you can still have those confidentiality, non-disparagement provisions in those agreements.
Yeah, again, that I do think we should wrap into our conversation of who's hourly, salary, overtime eligible, not supervision. This can be a good conversation for our listeners. What I think we're really saying, and then I want to review the poll results before we go, is do not just go get the severance agreement you've been using for the last period of time, pull it off the shelf, dust it off as you're going to use it, even if you think you're using it for a manager, until it gets a good look over. And you get a chance to edit it. It needs to have, some eyes on it who understand the current implication and what might be at risk, and therefore avoiding being the court case that sets the future stage. So I think you've said that really well, Burt. It's going to be an interesting time. But what we think, 6 months, National Labor Relations Act, you have 6 months. So probably anything older than 6 months, probably not. At least we would have some level of argument there. Nick, can we take a look at the poll results before we go for the listeners? All right. So here we have you ever had an employee challenge in terms of severance agreement in court? I can tell you I have. And it looks like the majority are no, but we have offered severance agreements large and by far most. And then there's about 20% to say they never offered severance agreements. And that's even better. Just be careful because they can be used at the right time as the right tool to help you move forward in a positive way. The next question that we had was, let's see here, Nick. What terms have historically been included in your organization's severance agreements? Of course, non-disclosure clauses, we're always worried about those. COBRA benefits, that makes sense. We can start to see these results come through, and compensation, stock options, and liability waivers being the most popular ones. Any comments, Burt, on those before we close out the program?
No, I don't see any surprises there. I guess the only surprise would maybe be on the first poll that I think there were 20% of people who've never used a severance agreement before.
Yeah.
I like you said, Phil, they can be the right tool at the right time in sticky situations to help you avoid litigation.
Yeah, and we can talk more about it. A lot of small employers sometimes don't get into this, family-owned businesses, those types of things that, they never really kind of get into that space. The larger you are, the more popular they start to become, and also the risk profile of the organization, the behavior of the organization, hiring practices, and so on. Lots of things that influence that. Thank you for joining us today, and we will be back here next week. We'll see you then, and hopefully Monique will not interrupt our program. Thank you very much for joining.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues. Forward our invites. Share the link aimea.org/thisweekatwork, or follow or subscribe wherever you get your news and entertainment, like LinkedIn, YouTube, Spotify, Apple Podcasts. We're everywhere you are. And you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.